3 arrests, 3 moments where the state tried to justify taking someone's freedom, and in each one the outcome turned on a single question. Did the police actually have enough lawful evidence to make the arrest stick? We're looking at 3 probable cause hearings before Judge David Fletcher in Harris County Criminal Court in Houston, Texas. These hearings happened shortly after an arrest, especially when there was no warrant. Under Article 15.17 of the Texas Code of Criminal Procedure, the accused must be brought before a judge without unnecessary delay. At that first appearance, the court explains the person's rights and examines the facts offered by law enforcement to decide whether there is probable cause to believe the offense was committed. If that foundation is missing, the person must be released. The first case came before the court on November 4, 2024, after Raquel Rodriguez had been charged with driving while intoxicated on October 28, 2024.
Yes.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
On page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turns 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the DIMS, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the 1-leg stand. He also noticed that I think she took off her boots for the 1-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per, you know,
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right. Please take a seat.
Judge Fletcher ultimately found there was no probable cause to support the DWI charge because, in his view, the officer did not have enough objective signs of intoxication to justify moving into standardized field sobriety testing. That matters because once an officer extends a traffic stop to investigate possible intoxication, the law requires reasonable suspicion for that added detention. Here, the state's case boiled down to 2 facts: the odor of alcohol, and Ms. Rodriguez's statement that she had 2 drinks, with the last one consumed roughly 2 hours earlier. Based on that record, the judge concluded there was not enough legal basis to prolong the stop for field sobriety tests under state and federal law, including Article 30, 8.23 of the Texas Code of Criminal Procedure. And if evidence is gathered through a constitutional violation, it cannot be used against the accused in a criminal case. Strip out the field sobriety results, and the arrest no longer had enough support to survive. The charge was later dismissed on February 24, 2025, but that was only the first warning shot. The next hearing, also on November 4, 2024, involved Keon Shaw, who had been charged on October 28, 2024, with fleeing a police officer under Section 545.42, one of the Texas Transportation Code. That law makes it a misdemeanor for a driver to intentionally refuse to stop after receiving a visual or audible signal from a pursuing police vehicle.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have them because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm gonna find no probable cause. All right.
Dismissing the case.
I know probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life. All right?
Yes, sir.
All right, man. Good luck.
Judge Fletcher again found no probable cause, this time because the officer's report never gave a specific factual basis for the stop itself. The central claim was that the driver was moving at an unsafe speed, but the report never said how fast. That missing detail became everything. While the Transportation Code does not expressly require the initial stop to be lawful in order to bring a fleeing charge, constitutional protections still control what evidence can be used in court. If the stop violated the Fourth Amendment or Texas law, then Article 38.23 bars the resulting evidence, including the officer's claim that the driver failed to pull over. Under the Fourth Amendment, Police need reasonable suspicion supported by specific, articulable facts before stopping a vehicle. And Texas courts have rejected vague, conclusory allegations before. In Ford v. State, decided in 2005, the Texas Court of Criminal Appeals ruled that an officer's bare assertion that a driver was following too closely was not enough without real factual detail, such as the actual distance between vehicles. Judge Fletcher applied that same logic here. Generalized labels like unsafe or suspicious were not enough. Without concrete facts, there was no lawful basis for the stop, and without admissible evidence, there was no probable cause for the arrest. The state dismissed that charge the very same day. Then came the final hearing in this lineup, held on January 27, 2025. Francisco Cerda had been charged on January 22, 2025, with engaging in organized criminal activity under Section 71.02 of the Texas Penal Code. That statute targets people who commit or conspire to commit certain crimes with the intent to establish, maintain, or participate in what Texas law calls a combination, defined in Section 71.01 as 3 or more people collaborating in ongoing criminal activity. The law reaches a wide range of offenses, from robbery and burglary to money laundering and theft, which was the alleged underlying offense in this case.
The last one, Your Honor, is Mr. Francisco Cerda. He's a precedent judge, and I wonder if I'm wrong on this.
Is that C or an S?
It's the judge. Okay.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
My concern is, if you may, I want to bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions the suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this fuel. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the 4 corners of the things, allege that my client was involved with this alleged theft.
Remember, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
can you does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough to bring trouble.
I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have that at this time.
but I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination, or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. And we have to
He's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure.
Once again, Judge Fletcher found the record fell short. The problem was simple but critical. The allegations did not describe any meaningful conduct by Mr. Serta beyond being present in the stolen U-Haul. And under Texas law, presence alone does not transform someone into a participant in organized criminal activity. In Munoz v. State, a 2000 decision from the Amarillo Court of Appeals, the court explained that a conviction for engaging in organized criminal activity requires proof that the defendant intended to join, maintain, or establish a group working together in a continuing course of criminal conduct involving more than a single crime or episode. The same case also made clear that merely being there during one alleged incident does not prove an agreement to keep committing crimes together over time. In Mr. Serta's case, the state's allegations went no further than saying he was inside the stolen U-Haul. There were no specific facts showing that he had joined an ongoing criminal combination, no evidence of a broader plan, and nothing tying the three individuals to repeated criminal episodes. Without that, the organized criminal activity charge could not stand at the probable cause stage. The state later dismissed the case on February 24, 2025. And that is exactly why these hearings matter. When someone is arrested without a warrant, their freedom can disappear in an instant, sometimes based on little more than an officer's version of events. A probable cause hearing is often the first real test of whether that arrest can survive legal scrutiny. When a judge carefully examines the facts instead of automatically approving the arrest, constitutional protections stop being abstract words and start becoming real. And when a court refuses to allow weak, vague, or unsupported allegations to carry the day, it protects not only the accused, but the integrity of the justice system itself.